Good evening. Thank you for joining us. My name is Beth Marsh, and I am the Director of Membership and Communications for the Organization of American Historians. We are joined today by 4 scholars who will look at the history behind the recent Supreme Court decision in the case of Dobbs v. Jackson's Women's Health Organization. Today's webinar is part of our Future of the Past series, where we look at our diverse past to engage and better understand recent events and debates. This series is made possible by a grant from the National Endowment for the Humanities. With that, I would like to introduce tonight's host, Dr. Erika Lee. Dr. Lee is a Regents Professor of History and Asian American Studies and the Director of the Immigration History Research Center at the University of Minnesota. She is also the President of the Organization of American Historians. Dr. Lee is the author of 4 award-winning books, including America for Americans, A History of Xenophobia in America, and The Making of Asian America. And with that, I will turn things over to Dr. Lee.
Thank you so much, Beth. Thank you to Sydney Siegel as well for organizing all of us. Welcome everybody to this very important discussion. The webinar is called The Dobbs v. Jackson Decision in Historical Perspective. I'm Erika Lee, and I'm joining you from just outside of the Twin Cities of Minnesota, which is located on Dakota land. Today, many indigenous peoples, including the Dakota and Ojibwe from throughout the state, call the Twin Cities home. Our history must account for past and ongoing injustices and indigenous dispossession. I'm proud to be president of the Organization of American Historians. The OAH is the largest professional society dedicated to the teaching and the study of American history. Our mission is to promote excellence in scholarship, in teaching, and in the presentation of American history, to encourage wide discussion of historical questions and the equitable treatment of all practitioners of history. As Beth mentioned, this program is part of our special series, Future of the Past, exploring our diverse history to inform our future. The program today could not be more timely. On June 24th, 2022, the Supreme Court ruled in the case of Dobbs versus Jackson Women's Health Organization, ruled that the Constitution does not confer the right to abortion, overturning nearly 50 years of precedent established by Roe versus Wade, 1973, and Planned Parenthood of Southeastern Pennsylvania versus Casey, 1992. In the next hour, we hope to discuss the history behind this decision, the impact for today, and then end with some thoughts on where we go from here. I think that it is extremely important to add that the OAH, along with the American Historical Association, recently issued a joint statement arguing that the SCOTUS Dobbs versus Jackson majority opinion rests on a flawed interpretation of the history of abortion criminalization in the United States. In particular, we state that, quote, the OAH and AHA consider it imperative that historical evidence and argument be presented according to high standards of historical scholarship. The court's majority opinion in Dobbs versus Jackson does not meet those standards and has therefore established a flawed and troubling precedent. For the entire statement, you can visit our website, you can find us on Twitter, and you can also visit the link that we will be placing in the chat. We will also place a link to the amicus brief that we filed during and for the case. And now I'm very pleased to introduce our panelists. First, joining us is Gillian Frank, a historian of sexuality and religion. He is the co-editor of Devotions and Desires, Histories of Sexuality and Religion in the 20th Century United States, published by UNC Press in 2018. And he's currently at work on a manuscript called A Sacred Choice, Liberal Religion and the Struggle for Abortion Before Roe versus Wade, forthcoming from UNC Press. You can listen to his podcast, Sexing History, co-hosted with Lauren Gutterman, which explores how the history of sexuality shapes our present wherever you stream your shows. Second is Felicia Kornbluh, professor of history and of gender, sexuality, and women's studies at the University of Vermont, and the author or co-author of 3 books, including the forthcoming A Woman's Life is a Human Life, My Mother, Our Neighbor, and the Journey from Reproductive Rights to Reproductive Justice, Grove Atlantic Press, available for pre-order now. She writes regularly for the scholarly and popular press, including for the American Prospect, the Washington Post, and the Forward. Stacie Taranto is an associate professor of history at Ramapo College of New Jersey and associate editor of Made by History at the Washington Post. She is co-editor of Suffrage at 100, Women and American Politics since 1920, Johns Hopkins Press, 2020, and author of Kitchen Table Politics, Conservative Women and Family Values in New York, University of Pennsylvania Press, 2017. Taranto currently serves on the Organization of American Historians Committee on the Status of Women in the Historical Profession. Welcome to all of you. I thought that we might start by placing the Dobbs decision in appropriate historical framework. In other words, I'd like to ask each one of you to consider how your own study of US history helps us understand the Dobbs decision and its overturning of Roe versus Wade and Casey versus Planned Parenthood. I thought perhaps we might start with Stacie and then Gil and then Felicia. Please, Stacie.
Hi, everyone. So obviously Supreme Court decisions have been overturned before, right? Plessy versus Ferguson is overturned by Brown with a series of decisions in between them leading to that point. So that a decision is overturned really isn't so unique. But what is unique and rarer in American history is just if you're thinking about the everyday lived experience of Americans, having Americans have a constitutional right one day and then the very next day not have that constitutional right, not related as much to my scholarship nor related to a Supreme Court decision. I immediately went to the 15th Amendment in my mind. This was an amendment to the US Constitution that gave Black men in the former Confederacy, many of whom were enslaved, the right to vote in 1870. And of course, it was constructed deliberately in a way that there would be loopholes that could later be exploited to stop that vote. Of course, women had tried to get in on the 15th Amendment and were denied that ability. But, I just thought about there was a time that these men were able to go to the polls, and not just go to the polls, but 400 Black men were elected to office in the former states of the Confederacy. 16 went to the US Congress, 2 to the Senate. And, they had those rights, and within pretty short order, less than a decade later, some former office holders, they had the constitutional right to vote and run for office. They now didn't even have that constitutional right to exercise a right to vote anymore. So my mind kind of went to that. Like, there were women who 5 years ago in certain states had a constitutional right to do something, to get an abortion legally, who on like June 22nd, had that right. And then, a couple days later, that was taken away. So that's sort of where my mind went, although it's not a really one-to-one parallel.
I want to invite us to think about Dobbs within 2 overlapping historical frameworks: a visual history in which we see the ongoing humanization or personification of the fetus, and a religious history, specifically the Catholicization of evangelical and Mormon understandings of fetal life. So I want to invoke these overlapping visual and religious histories to talk about the processes that saw graphic renderings in the forms of pictures, and also, as scholars like Jennifer Holland show, material culture that insisted for the public and for politicians that fetal life was human life from the moment of conception. Billboards, dolls, flyers, bumper stickers, all strategically and often racially in the rendering represented fetal life for specific audiences, even as terms like partial birth abortion, fetal heartbeat bills became part of our vernacular. All of this arises from a process, visual and rendering, of insisting that a fetus and a baby are equivalent, all to insist that abortion is murder. And this visual rendering coincided with and was part of the ongoing Catholicization of evangelical and Mormon thought, which shifted over time. So they too came to believe that a fetus is a child from earlier and earlier in the gestational period, almost to conception. So these visual materials, these material culture materials that I referred to a moment ago, often originated from Catholic institutions, but were quickly stripped of denominational markings for broader audiences, which saw religious ideas shape what folks think about and talk about when they talk about abortion. So these two histories, visual culture, religious history, were a piece, and they're a piece with coincided efforts that have gone on for close to 50 years to whittle away abortion access gradually over time, even as large-scale efforts to overturn Roe completely depended upon this architecture. All of this dovetailed with a yoking of anti-abortion politics with the Republican Party, as these activists found a home in the GOP, even as conservative politicians saw abortion, some of them true believers, others cynical, as a fundraising and a political mobilization tool. So that's the history that I would invite us to think about together.
I'm going to place Dobbs in the context of something that I do that I think many more of us could and should do, which is a kind of popular or social history of American law and American constitutionalism, bringing our social histories in line with legal and constitutional history. And so I'll just make 2 points. There are many, many things I could say along those lines, but I'll just say 2 things. And the first has to do with an amicus brief, a friend of the court brief that I participated in, that was submitted on behalf of the American Society of Legal Historians, ASLH. And we just took 1 point with 1 point of quibbling with the history that's presented in Dobbs versus Jackson and was presented in the briefs. And that's this claim that's very, very central to Justice Alito's argument, which is that Roe versus Wade itself produced conflict in the United States, that it produced political conflict and produced our modern polarization to a large degree. And Alito also claims that that Roe versus Wade is sort of foreign to our traditions. All professional historians who work in this area know that's not true. On the other point about whether Roe itself produced conflict, I think it's not as commonsensical. But we went very carefully through the record and showed that actually as soon as abortion decriminalization, like the campaign that I chronicle in New York State, as soon as that had a real chance of winning, there was intense conflict and there was a so-called backlash. So I want to lay claim as an OAH member, as a professional historian, to a kind of history that that's very different from the history that's represented in the majority opinion. And the other thing I want to say is that the majority opinion relies upon an idea about what our quote unquote history and traditions are, that the history and traditions that matter in terms of American constitutionalism. And it goes all the way back to the 17th century or even earlier defined texts against which to judge some of our major constitutional doctrines. And I think there's a real role for historians to play there in debunking. And particularly what I want to say is the feminist movement of the late 20th century actually transformed our history and traditions. And that's okay, right? We can recognize and we can respect the historical change work that was done in the 20th century as a foundation for our legal and constitutional concepts today. And in fact, we must, if we're going to understand the history and traditions that matter in terms of American constitutionalism. Thanks.
Thank you all for getting us started. I thought it actually might be helpful. We've been focused so much on the decision. I thought it might be helpful for us to go back a few decades, 50 decades to be precise, to discuss actually, how Roe and Casey were passed. Was it the action of individuals, organizations, communities, or protests, or all? And I thought perhaps we might start with Gil and then have Felicia add in.
Thank you. So when I think about the events that led to the passage of Roe, to the passage of Casey, I think it's really vital to see this as a combination of grassroots activism and protests, widespread civil disobedience. You can see that in the form of abortion referral networks, groups like the CCS or Jane, politicians on their ongoing legislative efforts, individual lawsuits and class action lawsuits brought about by activists, accidental activists or long-term activists, agitation by professionals in medical, legal, and religious fields, all organizing for change, widespread sympathetic media coverage. All of these were coalescing at the same time. And there were formal and informal coalitions between many of these groups. So if you were to look at a newsletter from, say, 1969 or 1970, from, say, the Association for the Study of Abortion, which is one of the many groups across the country pushing for change, its news updates of what's going on in the country with abortion rights efforts were like multi-page, and they would reveal a diversity of efforts all across the country as activists threw everything against the wall to see what would stick, whether it was the right to medical privacy, the right to abortion counseling, the right for a doctor to decide according to their medical expertise. All of these things were being argued at once. But underpinning all of this early on was a widespread sense brought about by sustained media coverage and also public health scholarship and legal scholarship that abortion restrictions were causing a public health crisis. For the legal profession, for the medical profession, for politicians, the sense that hundreds of thousands of people each year were seeking out abortions, that many of these were becoming injured or mutilated, that there was high maternal mortality rates or death rates, particularly among minority communities, created a sense of widespread motivation and crisis about what these laws were doing. And even so, all of these efforts were fueling a shift of meaning about abortion from something dirty that disreputable people would do to something that decent people would do to protect their families and their futures. We can look as early as 62, 63 with the thalidomide and German measles crises, Sherry Finkbein's trip to Sweden that began to portray abortion seekers in a different light. Abortion as decent, as Leslie Reagan has put it many times, deviant to decent. But also, it became increasingly associated in religious circles and feminist circles as a key to women's social equality. So when we think about what was happening on the eve of Roe v. Wade, there was an overlapping sense that abortion restrictions were dangerous and harmful rather than moral and necessary.
Yeah, I agree with all of that. And I just want to take it down to the socio-historical level and say, first of all, the people who changed abortion law were the people who sought abortions, right? And who caused crises in major hospitals across the country. And they caused crises for members of the clergy who then became activists, for the doctors who then became abortion reform advocates, for lawyers who took on some of these cases. So those are the people who are most responsible. The story that Leslie Reagan tells, which I think is absolutely right, is after World War II, there actually was an increase in prosecutions, that local DAs went on the rampage against abortion seekers and doctors who were providing, or other practitioners who were providing abortions. And in response to that, the people who were seeking abortions then start to show up in septic abortion wards in every urban hospital. And then every doctor who's being trained has to experience this, has to come into conflict with the depredations of this law. So that's the most important thing. And the other thing is, in terms of the development of the movement, I actually can say very specifically when abortion became a feminist issue, and it happens at the very first meeting of the New York chapter of the National Organization for Women. And Gerda Lerner, who was a good OAH member, was there, and so was Flo Kennedy, the the Black feminist radical attorney who later helped to bring the first feminist federal case around abortion, a New York case. And a couple of years later, my mother drafted the first abortion decriminalization law in New York State, which was the first full decriminalization of all abortion restrictions that had ever been proposed in a US state. And my mother was not a crazy radical person. She would never have engaged in civil disobedience. She was a labor lawyer and a member of NOW. But to her and to other NOW members, that became the position, the feminist position was no regulation at all, right? Abortion completely out of the criminal code, in fact, out of the legal code entirely. And even today, there are only 4 US states that, that have reached that level. So later there were more kind of militant and civil disobedience oriented so-called radical feminists who were involved. But first it was NOW. It was so-called liberal feminists who took what today seems like a very radical position. And I would also say that there were Black and Latinx activists who were very important in this history. And I document particularly the role of the Black Panther Party and of the Puerto Rican Young Lords in transforming the politics of healthcare.
Thanks to you both. Part of how we have gotten to where we are today is, of course, the backlash. And so just as we've recounted briefly the history of how Roe and Casey were passed, I thought we should also understand the backlash. So I'm going to turn to Stacie and then also Felicia to help us understand the history behind the backlash against these two laws.
Yes, so I'll try to give an overview of the anti-abortion movement. The first thing I just want to start with, though, and it really hit home for me on June 24th, I've interviewed probably 36 anti-abortion activists through the past decade or more. And to a T, they all told me that when they found out about Roe, they just first sat there with their heads between their hands, often at their kitchen tables, just feeling so dejected. And probably a lot of people felt that way last month for the opposite reason. And that's actually where the title of my first book came from. They just sat dejected at their kitchen table, but then they started organizing. So I will tell anyone here tonight that if you feel that way, start organizing. And there was really a split. Some felt that you have to go big, that the court had just given women a constitutional right to access abortion under certain circumstances. So they thought, in order to stop it all at once, we can just amend the US Constitution to give those same 14th Amendment rights to unborn cells from the moment of conception, all fertilized eggs, all the way up to fetuses. And this was a series of what they called human life amendments that they attempted to pass. Within that first year, 1973 and into 1974, there were 28 attempts to pass a human life amendment to the US Constitution, 21 of them from Catholic legislators, because as Gil and others have written about, and I've written about, most of the opposition was initially Catholic before later in the decade, evangelicals stepped up and joined in equal measure. But of course that was going nowhere, right? It's a very high bar to amend the Constitution, and they just didn't have the votes at all. So the consensus among the movement was, just like it had been before Roe on the other side, to kind of try to do everything, right? To try to initiate lawsuits, to try to go through legislatures, to do it at every level, local, county, state, federal. If you can shut down one hospital in one town that provides a lot of abortions, you have to consider that a win, a small step that will eventually lead to the ultimate goal. And as they're doing everything, all of their efforts are really focused along 2 lines: access and funding, right? Try to restrict access, try to restrict funding. It's all well and good if women have a constitutional right to an abortion, but if they have nowhere to have that abortion, they have no access to it, or they have no funds to afford it, then what good is that right? That's one way to effectively stop abortion from happening. And so that's the way they worked. I mean, the very clinic in Jackson, Mississippi at the center of the Dobbs case shows just how successful, even before Dobbs, they were along access lines, right? Eventually getting abortions so that they mainly were only done in most states in clinics, and then reducing the number of clinics, right? And then with funding, they were more successful initially. They got the federal Hyde Amendment that the Supreme Court then upheld, the Hyde Amendment passing Congress in '76, it being upheld, I think Felicia alluded to, in 1980. And that's really what they were looking to. So I think that, anyone who's tonight thinking of ways to do the opposite, it would be to increase access and to increase funding, and to know that you might have very small victories, but it really can't happen overnight. So that's really, that's how I sort of at a very high level look at the anti-abortion efforts along those two lines, eventually settling on the do everything.
Yeah, I'll just add, I think I said this a minute ago, but I'll just say again, the so-called backlash actually starts before Roe versus Wade. And I think that's important for us to note. It starts, I see it in the New York case, that it starts as soon as there's really a ghost of a chance of something changing, right? And so it's not like there's a steady state of anti-abortion political work going on. That's not true, even for Catholic legislators and for the church hierarchy. They have other priorities, like in New York, they're working on parochial school funding. Stacie and I have talked about this. But as soon as there's a piece of legislation, that's my mom's legislation, actually, that seems like it might have a chance of moving forward, there's a very concerted response. And the church hierarchy has priests across New York State reading a letter opposed to that specific legislation in every pulpit. On a specific Sunday, there's a major march in Central Park. There's demonstrating that Stacie's written about on the floor of the New York State legislature. And then after my mother's side wins in 1970 in New York State, 3 years before Roe, then the politics start to look quite familiar, at least to me, looking backward. And what the so-called pro-life side learns to do, they don't have a majority, but they learn to block, and they learn to use tactics that have become, I think, very familiar to us. So, for example, there's a liberal Republican governor, Nelson Rockefeller, in New York State, and he can't pass a budget. He can't, engage in the normal workings of government because there's a small cadre of pro-life legislators who block, who stand in the way. And there's a third part, there are actually two third parties, right, that develop immediately and start challenging Republicans in primaries, and Democrats, actually, because there are more Catholics at that point in the Democratic Party, right? So actually the guy who provides the critical vote for the 1970 law in New York gets primaried by a Catholic Democrat, and he's out of the legislature. I think it's important to not think about Roe as the kind of watershed that we're familiar with thinking of it as, especially because Justice Alito has kind of weaponized that understanding of Roe. And I think we need to peel it back. And I think it also helps us understand what a big deal this was. I mean, those of us who are historians of gender and sexuality, like, to legalize abortion and to see people who have the capacity to get pregnant and bear children as people who are thinking of themselves first, perhaps thinking of their own lives and their own well-being, and not thinking primarily of themselves as parents or mothers, that was a big deal. And no surprise that it was enormously controversial from the get-go.
Thank you to you both. Let's turn to two questions involving impact before we open it up to audience questions. And I'll just take this time to remind participants to use the Q&A function of your Zoom window to add your questions. I hope we'll be able to get to all of them, probably not, but please do ask your question and we'll start collating them. My first question about impact is for Gil. Can you discuss historically who has been affected by restricted access to legalized abortion the most? And when abortion was legalized, did legalization affect everyone equally?
Thank you. So we know that before and since Roe, those with the least economic and informational resources were disproportionately impacted by abortion restrictions. And depending upon geography, the groups who had the least economic or informational resources varied before Roe. In New York, we know that it was African-American and Puerto Rican women who were disproportionately affected. In Michigan, it was African-American women. In California, African-American and Mexican-American women. In the Southwest, it was Native American women. Now, the impact was multifold. Forced pregnancies, heightened maternal mortality rates, inability to access abortion earlier in pregnancies, therefore requiring later term abortions if you could get it, recourses to self or illegal abortions, and all of these had cascading effects. But one of the things I want to note as we think about who was impacted, so again, those with the least informational or economic resources, people who couldn't afford to travel, people who didn't know how to access the system, all were hit hard. But that cut across class lines. And I think that when we forget that in the dragnet of state-sponsored medical scarcity and stigmatization of abortion access, this also impacted upwards in class directions. Middle-class women and above also couldn't find abortion information. I have letters written to various abortion rights associations, abortion access associations saying, "Thank God I found you. I've been searching for 3 months for any information," or "I was forced to bear my child because I didn't know where to go." And these were letters written by white women married to physicians who still couldn't find it in the middle of the country, women who were in religious households and therefore didn't know what questions to ask. And so when we think about abortion access, knowing who to call, knowing where to go was a key part of it. And then being able to answer questions, what will happen to me? Can I afford it? Is the doctor safe? All of these impacted women across class lines with a disproportionate impact on the poor. So after legalization, and we can chart that earlier with California, 67, 68, New York, 70, and elsewhere, we can see it globally in England and other places. Again, information access, being able to navigate medical bureaucracies was a huge problem for many who wanted to get these services, especially if you weren't familiar with how to navigate and advocate through hospitals' red tape. So entire organizations started cropping up in the midst of liberalization or repeal in California and New York, later on in southern states and in Kansas. What do you do when you want to go to a hospital? How do you advocate for yourself? How do you negotiate with a hostile physician? Many people were unable to cut through this red tape without assistance. And so legalization didn't affect everyone equally. If you were familiar with the medical system, if you were familiar with negotiating with doctors, if you had a good sense of what to expect, you were able to get it, but many people just weren't literate or empowered to do that without outside assistance, if at all.
Thank you. This question is for Stacie. The ruling of Roe and Casey are largely based on conceptions of the right to privacy, with their being overturned, as well as Justice Clarence Thomas's opinions. There have been many fears that have been raised about other cases based on such privacy rights, including Griswold versus Connecticut, Lawrence versus Texas, Obergefell versus Hodges, and even potentially Loving versus Virginia. Without speculating too much on the future, could you touch on these laws, the role that they may play in the history of reproductive rights, how they were initially affected by the passage of Roe versus Wade, or vice versa?
Yeah, so the simple thing to say is that, Roe, the constitutional right to an abortion, hinged on of privacy, of the right to privacy that is inherent in the due process clause of the 14th Amendment. And Roe was not the first case to use that argument, right? Famously, Griswold versus Connecticut, giving birth control access to married couples in 1965, used that then novel, well, not completely novel, but use of privacy in that way. And that's what Roe was built on, right? So, and then you see it expanded eventually, that same right to give birth control to unmarried couples, to give women the right to an abortion, to invalidate sodomy laws, this idea that you have this personal liberty that is protected by the Constitution, and that involves the right to do what you want with your person, right? With your body. So, of course, in the Dobbs opinion, the majority justices are very careful in Alito's opinion that he wrote to say, oh no, none of these cases will be impacted, even though they all hinge on the exact same thing. So first of all, a lot of those who joined the majority also said that they believed in stare decisis and precedent, and that they wouldn't overturn Roe in effect, and then did the exact opposite. I love this quote. I don't know if Professor Reva Siegel is out there. She and I have collaborated together in the past, and I just edited one of her great articles in Made by History, as well as articles by my co-panelists as well. But she just had this quote sort of talking about this notion that just because they say in the opinion those rights are protected, should we believe them? She wrote, quote, "The majority," in Dobbs, "suggests that these other rights are not threatened by Dobbs' logic, even as it adopts a method of interpreting liberty that discredits them, and even as Thomas himself calls for overruling the relevant cases in his concurrence," end quote. So I do think that we should, because Roe hinged on the same use of the right to privacy, the right, this idea of liberty in the 14th Amendment, I do think that those other cases are now vulnerable, no matter what it says in the Dobbs opinion.
Thank you. Thank you so much. And thanks to everyone who's posted questions in the Q&A. I'm going to start with a few, and I'm also going to combine a couple together. And I open this up to Gil, Stacie, Felicia to answer. But the first question is from Donald Rogers, and it's about the dissent. Donald asks, might the panelists discuss the joint dissent in the Dobbs case by Breyer, Sotomayor, Kagan? Does the dissent embody a more correct version of the history of abortion? Will it have any long-term legal or socio-political weight? Does anybody want to start us off with it? Okay, great.
Yeah, I'll say something about it. I think everyone should read it. I felt very, I wrote a piece in which I said I felt befriended by it, but it felt like I was hanging out with these very brilliant people who have been totally marginalized and sidelined by the current court and by the current movement of constitutional doctrine, official majoritarian or court majoritarian, at least, anti-majoritarian in terms of the population of the United States doctrine. And so in the way these things go, of course, in the short run, it doesn't do very much. I think they get the history more right. In fact, Justice Blackmun in 1973 got the history quite right. And what Justice Blackmun said about the fact that, under Anglo-American common law, abortion was mostly not prosecuted, certainly not before so-called quickening. And even after quickening, it really wasn't prosecuted. Historians have shown us, right? Neither in England nor in the United States. So, they're working off of a more professional history, more professional understanding of the history. And I think they're also calling us to understand some of the ways in which the Dobbs majority opinion is itself a historical watershed, not the kind of watershed we usually celebrate. So I think the dissent, like many of the dissents that have been written, especially by Justice Sotomayor recently, is really useful in that way as a kind of rallying cry. But I think what we have to conclude is that they really are sidelined, and it's not going to be constitutionally meaningful under anything like this court or most of the other federal courts. We have to look elsewhere if there's going to be some countervailing action. It's not going to be from those three justices, or even from the new Justice Brown, who's going to be ascending.
I'm going to put three questions together and invite you to address them. And they all pertain to basically, what are the options now? So the first question is, what is the history of congressional/legislative changes to the Supreme Court? Connected to that is Carolyn Edwards' question, are there any lawsuits in the works that could go to SCOTUS to overturn this latest decision? And I think connected to both of these is from Eileen Boris. Going forward, is the 14th Amendment now damaged for legal strategy? Is there any possibility to use the 13th Amendment or even the 19th? I invite any or all of you to try to address one, two, or three of these questions. Felicia, you're unmuted. You've got your hand on the buzzer first.
I'll start, but I won't go on too long. With this court, we're not going to, I'll just say, if you're interested in abortion rights, you're not going to win in this court. And one of the things I try to show, and this is very much in line with the work of many of my colleagues in the OAH, is that social change happens in a lot of different places, and in the realm of abortion rights, social change and legal change have actually happened in a lot of different places. Certainly from the ground up in terms of mass movements, but also in legislatures, in regulatory agencies, in hospitals, which have codes of conduct, within professional medical societies. So there are many fronts on which somebody who's interested in abortion rights may be able to pursue those. The current United States Supreme Court is not one of them. And we could come up with we could play kind of an interesting game of what would be the right doctrine or the most robust doctrine. There's been a lot of work, in recent years by smart con law scholars about the 13th Amendment and about its originally very robust meaning, and could we bring that back in a variety of ways, and labor rights and so on. That's all nifty. But the current Supreme Court majority isn't going to be interested in any of it, in my view. And 14th Amendment jurisprudence, I think, to Eileen's question, is really in trouble. If if for every 14th Amendment constitutional right, we have to do the kind of so-called historical analysis that Justice Alito proposes, I think we could be in for a lot more cases like Dobbs, or opinions like Dobbs.
Yeah, I couldn't agree more with Felicia about this current 9, even with the incoming Justice Brown. I mean, nothing's going to change with them. I mean, I will point to the fact that the number of justices was changed 6 times in American history. We settled on the current number of 9 in 1869, so it has been quite some time since we've changed it. But there are proposals to maybe raise it to 13 to account for the 12 circuit courts and the Court of Appeals, so 13 circuit courts. Justice sort of corresponding to each. That's one proposal. And then, of course, there's the Women's Health Protection Act, another federal law, but this going through Congress. It's already passed the House. There just aren't the votes currently in the Senate for it, unless you get rid of the filibuster, as President Biden has discussed being open to now, potentially, and or elect more senators, probably Democrats at this point in history, who would be able to get through a filibuster-proof majority to pass that in the Senate and enshrine that in federal law. But with this current court, there have been people who have said maybe instead of relying on due process in the 14th, you could rely on equal protection. I mean, I just feel like it's all going to be a no-go with this crowd.
I'm just going to add on very quickly that we're asking these questions from a sort of older intellectual framework and not under the sort of auspices of this radical right-wing court. We don't know what sort of laws they're going to authorize in terms of interstate travel, free speech, all of these things around abortion. We don't know how capacious the Dobbs decision is going to be and how it will be allowed. So for us to think about legal strategy when we don't have a sense of the terrain yet, I think we should brainstorm and have all options available, throw everything, including the kitchen sink, at it. But we don't know what the lay of the land is going to be yet in terms of how restrictive these laws are. Right now, it looks like it's being thrown back to the states, whatever that means, but it's not going to stop there. Each state is going to become a battleground if they don't propose and aren't able to enact national bans on abortion. So I think that where I would focus in terms of efforts or strategy, and it's hard to be prescriptive, is echoing what Stacie said earlier, increasing access, increasing resources. I think that that is the most solid plan forward.
The last question I'd like to pose, and I'm sorry to all of the audience members who did put questions into our chat and Q&A functions. There's just simply not enough time. But the last question I'd like to pose to the panelists places the US in more of a global context. And that is one that asks you to speak about the Dobbs decision in the context of expanding access to abortion in other parts of the world, especially Latin America.
Yeah, well, I'll start. And thank you for that question. It is astounding that the United States seems to be going in this direction, which is kind of where Poland is. And many countries in Latin America and Ireland have gone in the other direction in recent years. And so I'm not a historian of Latin America or of Ireland, but I know that to be true, and I know that there were successful strategies that worked there. And at least it shows us that historically Catholic or majority Catholic countries are not immune to effective social and legal change campaigns. Yeah.
Nor am I a historian of Latin America, but what I would add as we think about what's happening in the United States is a broader erosion of democracy. Now, what we have in the United States and what has plagued abortion access from the outset is a lack of social health care for all, whereas many of the other countries that offer abortion have basic access to healthcare, fully funded or partially funded, two-tiered systems as they have in England. And so all of these have been shaping factors. But what I want us to think about this anti-abortion rollback in is within the broader rollback against minority rights, against democratic rights, against voting rights. Fascism loves a good sex panic, and fascism really does love eroding personal autonomy as a way of prepping people to coincide or to align themselves with various forms of authority. So I think that as we talk about this backlash against abortion, this long march, we need to see this not as apart from the CRT panic, not as apart from the anti-trans panic, but as coincident with them, as interlocking with them, as a way of instituting a very rigid set of sexual, gender, and racial norms.
I feel like the theme erosion of democracy is driving all of our Future of the Past webinars and much of the work of the OH these days. The last question that I want to pose to all of you is basically a continuation of what we've been talking about already, but is what do we do now? And to be more specific, perhaps I'll offer a few more detailed questions. How does the history before Roe help us understand what is at stake in a post-Roe world? What can we, historians and non-historians alike, do in the days, weeks, months, and years ahead to support reproductive rights and justice? And lastly, if that wasn't enough already for you to answer, what's the key takeaway that you'd like to share with our audience today as we acknowledge, reflect upon this historic event?
I'm going to try to echo something that Felicia started us off with, actually, and try to be hopeful that, we know what happens when abortion access and funding is restricted. We know it continues, and we know that it creates crises in women's health care and other pregnant people's health care. And we know that people who join anti-abortion movements may one day find themselves in need of abortion services, whether for a miscarriage or an abortion. So I do feel like that we've seen this before in many ways, and it typically does lead people to mobilize at local, state levels to begin with, to try to expand access when they realize what the reality of contracted access to a full spectrum of healthcare means in their daily lives, because a lot of people sort of don't realize what it means. And so I'm gonna say, it's now at the states. And maybe that's what we do. We return to the state level as we wait out a federal solution.
As for what we do next, or as our people are looking for ideas of how they can contribute, I would beg people not to try to reinvent the wheel. There are so many organizations out there that have been doing the work for a long time in preparation for this day. And so part of seeing what's going on, to build off of what Stacie says, is to see who is active in your local area, who is doing the work to provide medical access, travel access, and so forth. I also want to note, there was so many questions layered in there, Erika, that you said, what can we learn from pre-Roe about the past? Part of what people argued for, and it seems so fundamental, is the ability to separate sex from reproduction, the ability to have sex for pleasure, this idea that sex is not procreational. This seems to be at stake again. And so I think that as we return to first principles and articulate these intersectional ideas, part of what people are arguing on the other side, the anti-abortion side, is people are out and out saying, just have sex for procreation and don't have it otherwise. This is the world that some of these folks want to return us to. And so sexual liberalism or sex radicalism puts pleasure at the center, but also sexual freedom. And I think that thinking about that within this broader context of access, we can't separate them.
And I think, I love those answers. And I think my take home point would be organizing works, activism works. That's what my book teaches me about the movement to decriminalize abortion. And I think people who've studied the pro-life movement also find that. So I would say, if you have disposable income, there's the National Network of Abortion Funds, or your local abortion fund, or of course Planned Parenthood, but the funds tend to be smaller, and they do a lot of this work of helping people get across state lines. And there's a wonderful fairly new group called If, When, How, Lawyering for Reproductive Justice, that is it's not doing fancy law cases, it's doing these on the ground cases of people who get into legal trouble because they're seeking abortion or miscarriage care. So that's really important. And I also think we should actually organize. We should, of course, write and teach with passion and don't let anybody shut us up. And we should organize. We had an organization years ago called Historians for Social Justice that did sort of ad hoc lobbying work. I think we should be historians for social justice.
Thank you so much. I'm just going to echo something that one of our audience members, Meg Tomlins, put in the chat. Thank you for giving us hope tonight. I'm going to add, thank you for giving us understanding, for giving us that will back. I'm sure that many have felt that, not just in this past week, but over the past several years, this erosion of democracy has been bearing upon us all. But you all have been, and Meg says, yes, it's been devastating. Yes, but you all have shined a light on what we historians do best, and also what we can do beyond our research, writing, and teaching. So thank you so much. Thank you everyone for joining us. I'm going to turn us back over to Beth Marsh.
Thank you guys for a wonderful conversation. This has been really informative and helpful. And thank you also to our audience who joined us this evening. The recording of the webinar will be available tomorrow, and for everybody who attended, you will get an email letting you know how you can find it. Our next Future of the Past webinar will be on July 19th at 6 p.m. and we will be delving into Native American and Indigenous history issues. So thank you until next time.